So what tribunal procedure will we follow? The timetable for an appeal that's adopted under the national trial will remain very similar to the timeline for an existing appeal at the Sen Tribunal. So week 0 will be when the appeal is registered. We will then proactively case manage that appeal, and that will be done by either a registrar or a judge who will look to identify the issues in the appeal, identify the evidence required to actually decide those issues, and clarify any recommendations that are being sought. What we are looking to do is make sure it's very clear what exactly is the issue that's brought before the tribunal, and to ensure that we have the jurisdiction and the powers to make either a decision on an educational issue or a recommendation on a health and or social care issue. The local authority will respond to the appeal at week 6. This remains the same as we have in all other appeals, and there will be a final evidence deadline for both parties at week 7. At week 8, further case management will be proactively put into place, and this may include a telephone case management hearing if it's identified that the appeal may not be ready to be heard, or if there's further evidence, or if there is outstanding requests made by the parties considering the appeal. Week 10, the evidence bundle will be produced by the local authority, and week 12, we will hold a hearing in the appeal if that's required, or we make a decision on the written evidence if both parties have consented for that to happen. We will be looking to issue a decision in an appeal under the national trial within week 14. At week 14, we'll issue a decision in the national trial appeal. The tribunal already has established case management powers, which include the power to hold a case management hearing. This is usually done on the telephone, not face-to-face. We can require parties to produce evidence. We can actually require third parties to produce evidence, and we can witness summons somebody to come and give us evidence at the tribunal. We consider this is a draconian power which we don't use lightly. However, if required and we deem that evidence is essential to the issues that we've got to decide, we will consider using this power. All evidence from any professional who are coming to the tribunal should specify a child or young person's special educational, health or social care needs, the provision required to meet those needs, and the outcome expected to be met when the provision is put into place. This is an essential point to make for professionals coming to the tribunal, and we are looking for them to be very clear about actually what are the needs that they feel that the child or the young person has based on what evidence, i.e. have they assessed the child? If they have carried out formal assessments, what are those assessments? Have they observed the child? How many times have they met the child? And professionals should be really clear that they should make sure that this evidence is put into context so we actually know on the basis of what they have made their decision. Once needs have been established, then the professional should go on to look at the provision that's required to meet those needs, and it's very clear from case law that we need those needs specified, and I'll say slightly more about that later. i.e., what do you expect to happen if this provision is consistently put into place, and what will you expect the result to be? Written evidence coming to the tribunal usually is in the form of existing documents such as IEPs, individual education plans, annual review records, school reports, any medical diagnosis or professional reports. Evidence from the EHC assessment on which the local authority based their decision is obviously very central to our decision-making process, as is secondary evidence around a school or a college, such as their Ofsted report, prospectus or SEN information report. Evidence specifically obtained for the tribunal case often includes updated reports from professionals already involved in working with a child or young person, or witness statements, i.e. from learning support assistants or schools or other professionals that are involved in supporting the child or the young person. Oral evidence given at a tribunal hearing should add or supplement written evidence. It shouldn't look to just repeat evidence that's already there within written documents. It should be contained within the area of the expertise of that particular witness, and usually each party can have up to 3 witnesses come to a SEND tribunal hearing. At this time, we're not proposing to extend that for national trial appeal hearings, although obviously we'll look at applications for a 4th witness in the light of the issues brought by the national trial. So we need to make a further application for a 4th witness if that's what you require. We, of course, can in the tribunal make arrangements to hear evidence in other means, i.e. electronically, via telephone, on occasion sometimes via Skype. And as I've said previously, we do have power to summons a witness, which we will use if we feel there's no other alternative other than to issue a summons. I want to say something now about specification, as if evidence is specified, it actually leads to the job of the local authority and the tribunal in any appeal being somewhat easier. Case law established under Clark and Somerset said that evidence should be so specific and so clear as to leave no room for doubt as to what has been decided is necessary in the individual case. Very often specification of hours per week will no doubt be necessary, and there will be a need for that to be done. This is good case law and should be something that everybody is aware of when they're giving evidence to the tribunal. Evidence given as part of advice and information gathered during EHC assessment or coming to the tribunal once an appeal has been registered needs to be really clear about what the child's needs are, the provision required to meet those needs, and the outcome expected. What is not specification are the use of words such as required, regular, access to, as advised, or when necessary. These don't tell us clearly who must do what, when, where, and how. What is specification? Specification is where evidence tells us clearly who should do what, when, where, and how often for, and also covers the monitoring arrangements for that actual therapeutic input, for instance, or the type of support that a child or young person requires. A tribunal hearing under the national trial will have a panel that's composed of 3 people. One will be the judge, the second will be a specialist education or disability member, and the third will be a health or social care specialist member.